All right, the question is can we enter a motel room to freeze it in anticipation for a search warrant? And can we also actually hold on and detain the suspects of a sexual assault at the same time? Okay, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you another Roadside Chat. This question comes from an officer in Kansas. So it's a pretty good scenario, actually. And so this basically we have accusation that a sexual assault occurred in a motel room. Two juveniles, along with their mother, are living in the motel. That is their residence. Two victims say that they were sexually assaulted inside the room. While the victims were being interviewed, the detectives were like, all right, let's lock that room down. Let's freeze it. Let's pull the people out and so forth. And the problem, though, was that there was no evidence that the suspects even knew that they were being, that they were targets of a sexual assault investigation. So as far as they're concerned, everything is just a hunky dory. Well, this officer who's asked me this question goes back and forth to detectives, and he's like, "Look, I just can't go in there and just start pulling people out without some kind of exigency, right?" And finally, they come to an agreement to do it because not only do they want the room, but they also want the suspects. And if we the longer we wait, the more likely it is that they're going to take a shower, they're going to destroy evidence and so forth. Okay, so the officer knocks on the door. Mom comes to the door. They say, "Hey, look, we really need everybody out of this room." They comply. The suspects are then seized. They get the warrant. Come to find out, that the victims were actually lying. Probably got caught having sex, by their parents. And, what do? They say, "Hey, it was not consensual." That's how they get out of it, right? That stuff does happen more frequently than I would like to admit. So the question, though, is, look, what is the rule about pulling people out of their homes? Okay, well, look, the rule is that you may do a premise freeze under a few conditions. So some ground rules here. Number one is if you want to just keep people out of the room, okay? You don't think anybody's inside the room. You just want to kind of like keep people from going in while you get the warrant. Absolutely, no problem. That's going to be easy. You obviously know that if you let them in the room and they know you're there and so forth, they can destroy evidence. But even if you just show up to the house and like, "Look, you guys aren't going in. We're going to hold on to this while we get a warrant," that is actually no problem. That is the same thing, legally, in principle, the same thing as holding onto a car for a warrant, holding onto a backpack for a warrant. Obviously those are containers. The house is one huge, massive container, but the house is obviously protected like no other. So I'm not saying it's exactly the same, but legally it's similar. Okay. Now, the next type of premise freeze that we have is you're already inside the house, okay? You're there, you're conducting this investigation, you're inside the house with consent, whether it's a domestic violence case, whether it's a sexual assault case. Let's say that uncle's staying at the house, during Christmas time, he's suspected of, sexually assaulting his niece or something. And then you're like, okay, I have probable cause here. I'm gonna get a warrant for the bed sheets and all this kind of stuff. You start pulling people out. That is absolutely authorized as well. That case is Illinois versus MacArthur, okay? Where the U.S. Supreme Court has said, if you're inside of a home and you're gonna go seek a warrant, and if you just left and came back later for the warrant with the warrant, that evidence could be destroyed, then clearly it's reasonable to either A, stay in the house and basically just freeze it all and be like, all right, we're not leaving until we go get why the warrant's brought back, or what most likely will happen is cops will start pulling people out. All right, the last one is this whole entry and exclusion issue, okay? I have been teaching for many, many years that police officers do not have a right as just the authority, I should say, just to automatically start entering homes or start pulling people out of their home just because you have probable cause and you're going to get a warrant. Instead, you don't have the judicial authority yet. So when you're asked, all right, what gave you the authority to enter my client's home, an hour before the warrant was even signed? What are you going to say? You definitely cannot say, well, the exception is I'm getting a warrant. The exception is to have probable cause. There is that doesn't exist. That exception does not exist. Show me a case that says that you can, as a matter of routine, enter a home that you're not even in yet and start pulling people out while you go seek a search warrant. It doesn't exist. Okay, so the case we're going to use there is a case called United States versus De-escalation. I'm saying it wrong, but you get the point. I'll leave the description below. But this is what they said. They said at least some members of the Boston Police Department may have mistakenly believed that they were free, absent a search warrant or exigent circumstances, to enter a dwelling in order to freeze the scene. The district court was quite correct to state strongly that this is not the law. There is no question that the police had no right to freeze the Quincy apartment where that meant entering it, looking around, searching. I guess they kind of went over, searching for stuff, right? All the while ostensibly waiting for someone to get a warrant. Nothing in the First Circuit or Supreme Court case law remotely justifies such a step, nor should it. Searching without a warrant and entering as a search to some degree, you're going to see something in plain view probably, on the assumption that the magistrate will no doubt agree with the officers that there is probable cause to search that location at that time, makes a mockery of the Fourth Amendment protection, the warrant, and thus the review it requires, and reduces it to a technicality. Okay, so you have to have some level of exigency. Okay, so let me also share, some other cases. There was a case also holding, and I'll put this in the description below, that there was no reason to believe anybody was home. Okay, so why are you entering a home when you don't even have any reason to believe anybody's even in that damn house? Okay. Another case was they entered the home and they said destruction of evidence, but then they were asked what destruction of evidence. They couldn't even provide any reason to believe that the people were even aware of police presence. Okay, so let's go back to this case. Those are the ground rules. Let's apply it to this case. I believe that it's defensible to believe that if the crime just occurred, right? We're talking about minutes, hour or so, and they're in the apartment, and the victims are gone, and they were raped, and of course, if this is, one of these issues where the victims are saying, straight up rape, I do believe that a suspect would be motivated to get rid of the evidence as quickly as possible, right? Because it is reasonable to believe that a victim of a sexual assault that has gotten away or was let go is going to run right to the police, and the police are going to seek a warrant. So, in the minds of a criminal, I think it's arguable that, hey, look, the police are coming eventually. Like there's two victims, there's two suspects, but you're going to need to articulate that. So we have that here. So I want a recency. If this is like a 3-day-old case, that's not going to work. What else? What about, it's like closer to nighttime. It's at nighttime. People take showers at night, maybe to go to before bed. It's these things. Maybe the suspects made comments about the police, and they're you're not going to find any evidence here. If you report it to the police, you're not going to find any evidence. I mean, the point is, I respect immensely that this officer kind of pushed back on the detectives and said, hey, look, why are we going in there? Why are we starting to pull people out of their home? Because that is the right answer. That's the right question. We can't just do it blindly. At the same time, I like the fact that at the end of the day, they talked it out and they came to a conclusion that this might have been the right thing in this particular case, depending on the facts. Look, I do not have any specifics on this case. I don't think it'd be fair to tell me what it is. It's their investigation, but the principles are the same. If you're going to start pulling people out, and hey, come out of this house, or you start physically grabbing people out of the house, before you do that, just make sure you have some kind of urgency here so that you don't get in trouble with the courts, especially if somebody gets hurt. Because if one of those homeowners gets hurt, and you're like asked, why are you even doing this in the first place? And you're like, well, that's the way we're trained and so forth. There is no, that's the way I was trained exception of the Fourth Amendment. you're going to be starting your way all the way up to $1 million lawsuit if somebody gets killed and so forth. So just know what you're doing out there and make sure you're making good case law. And again, I'll just say this one more time. I do respect, and you should too, when officers have the freedom to talk things out, right? Have those arguments. Argument is not a bad word. I mean, lawyers argue in court. They do it in a respectful manner. It's professional to professional, but they argue things, and then the truth will come out, and the right answer will come out. I hope this has helped. Get it right every single time. If you like what we're doing here at Blue to Gold, like, subscribe, share with your friends. Until next time, my friends, you stay safe.